Today was day 11 in Karen Reed's retrial, and in order to recap everything that happened in court today and to play for you some of the clips of the highlights of the testimony, let's get rolling. So we started off with Connor Keefe today. Connor Keefe is a Massachusetts State Police trooper, and he worked with a fellow named Michael Proctor, a former Massachusetts State trooper. So they worked together on this case, and one of the things that Connor Keefe did is that he got the consent from Jennifer McCabe and Kerry Roberts in order to download and extract their phones. So part of the reason why Hank Brennan wants to show that and wants to show the jury that is to show that Jennifer McCabe and Kerry Roberts do not have any sort of feelings of guilt, which is why they're turning over their phones so readily and they're being so forthcoming, because they did nothing wrong after all. If they actually did something wrong, then maybe they will not want to turn over their phone so easily. So that's part of the reason why Hank Brennan wants to show that they had no problems turning over their phone. They signed the consent, and that was one of the things that Connor Keefe did. Another thing that Connor Keefe did is that he actually responded to 34 Fairview between 5 and 5:30 p.m. to help process the scene. Now, remember, the CERT team was already there. They were processing the scene as well, collecting the evidence. But what would happen is that the CERT team would find something, and then they would turn it over to Connor Keefe, who would then put it in an evidence bag and bag it for evidence. So that was another part of what he did. He showed the jury the shoe that was found. It was located right near the curb where the Commonwealth is going to suggest that John O'Keefe was hit, and that's why his shoe fell off, because sometimes in these pedestrian collisions, a shoe falls off. And he also showed some pieces of taillight that were found by the CERT team. So that was the extent, essentially, of the direct examination. Now, on cross-examination, the first thing that David Yannetti wanted to establish was the fact that Michael Proctor was the lead investigator in this case. Now, the reason why the defense is so keen on showing the jury that Michael Proctor was the lead investigator in this case is because you are going to be hearing about some misconduct of Michael Proctor. And the closer that they can tie Michael Proctor to the investigation of this case and to show that he was in charge of this entire investigation, well, then the misconduct is going to play a much bigger role in the jury's determination. But if the Commonwealth is able to distance Michael Proctor from the investigation and say, yeah, he was just one of the people, and yeah, okay, so he's a bad apple, but the rest of the investigation was good, well, then, they'll be able to make the argument to the jury that Michael Proctor, even though he did act inappropriately, perhaps with misconduct, and was eventually suspended and fired, well, he was just one small piece of the puzzle. This is why we're kind of seeing this already play out. So we already heard yesterday from Paul Gallagher when he was on the stand. And Paul Gallagher, if you forgot, he was the leaf blower guy. He was also the solo cups and the stop and shop bag. So yeah, Paul Gallagher. So yesterday in his testimony, he tried to kind of also say that Michael Proctor, he doesn't even know if he was the lead investigator in this case. It's a group effort. So right away, you're kind of seeing that. So I think David Yannetti right away wanted to establish that no, actually Michael Proctor is or was the lead investigator in this case. So let's see how that question gets asked right here in this clip.
Within the CPAC or the Norfolk County detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation, no.
You have not yet?
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
Okay, so very clearly he got him to say and admit that Michael Proctor is or was the lead investigator in this case. And I don't think you have to be a body language expert to understand that the last place that Connor Keefe wants to be is on that stand answering questions from David Yannetti. And if you watch the entire cross-examination, you can definitely tell that. So I think the body language experts have a field day with this testimony. But either way, he did have to acknowledge that Michael Proctor is or was the lead investigator in this case. Then he moved on to another interesting question, which he asked him. He said, you did help out Michael Proctor in this case. And one of the things that you did was you were there. You participated in Sarah Levinson's interview. We already heard from Sarah Levinson. So he said that one of the things that you did was participate in that interview, right? And actually, he got a very interesting answer to that. I'm not sure if he was expecting this, but listen to what happened here.
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
So he doesn't recall being there, which some people would suggest, hey, is this again Michael Proctor adding people there who really wasn't there to show that there's another state trooper there and Michael Proctor's not doing anything that looks nefarious, which seems to be the word of this case. So is that possibly what's going on? And then eventually he actually showed him, David Unetti showed him the report, which showed that he was there. And then he said, oh, okay, yeah, I guess I was there. And maybe he does remember being there. But I mean, right here was a moment where, hold on a second, people can start thinking, is this another thing that Michael Proctor did in this case, which was not on the up and up? So he put that in, and he also talked to him about the fact that he got the videos from C.F. McCarthy's and the waterfall, but eventually Michael Proctor was the one who wrote the report and did the analysis about the videos. So it's kind of trying to show that Michael Proctor was the one who was the lead investigator in this case, even though you were helping him, you were getting the videos and you were participating in the interviews, but he was the one ultimately who was writing all these reports. Eventually also got him to talk about the fact that he was the only one who was at the autopsy of John O'Keefe. He was there. And of course, he does have to give some input, some of the facts that they know about the case up until that point to the medical examiner. And ultimately, as we're going to hear, most likely from Dr. Scortibello, the manner of death was undetermined in this case. So he brought that fact out as well. Then there was a break. Okay, now there's a bigger break than normal because there was an issue that Robert Alessi brought out, because the next witness that we're going to hear from was Jessica Hyde. And Jessica Hyde is one of the digital forensic experts that was hired by the Commonwealth. So we already heard from Ian Whiffen, and she's going to testify in a moment. But before we get to her testimony, this is where there was a bigger break, and there was an argument about a certain line of cross-examination that Robert Alessi wanted to explore. And that was that apparently there were some cases where a judge determined that Jessica Hyde was unreliable as it relates to a specific data point. Okay, so it had to do with some location data, and because of the Apple source code, it had to do with some digital forensic stuff, expertise that is a little bit above a lot of our pay grades. And the point is that he wanted to show that if you don't have some of the more reliable ways to examine the phone, so then, you can be deemed unreliable. So he wanted to bring that out, the fact that this other judge determined that, to show her that she's using unreliable practices. So this was brought up last minute. There was some argument here, and I didn't do research on the topic, and I didn't look up the case. Unfortunately, a lot of times I like to do that, but I just didn't have time, and this is kind of sprung on everybody last minute, and that's how kind of Judge Canoni, so was sprung on her also. She wasn't so happy with that, and then eventually what she said is that she is not going to allow Robert Alessi to cross-examine her, Jessica Hyde, based on that opinion, where this other judge found some of her data as to be unreliable. Okay, but again, the data didn't have to do with the 227 search. It had to do with location data, so it was a different area anyway. But anyway, so that was Judge Canoni's ruling. So then we moved on to Jessica Hyde. So we're not going to go through the entire explanation of Jessica Hyde's analysis on John O'Keefe's phone and Jennifer McCabe's phone, because quite frankly, it's probably above a lot of us. And I'm sure that there are some people with software engineers and computer programmers who could understand all this, but I think a lot of it was over the jury's head. I was trying my best to keep up and follow up for a lot of it, but it seems like, she was definitely talking on a level which was very, very high. And it seems like if you don't have a good education in this, you may not be following 100%. But ultimately, she came to 3 conclusions, which we will play for you right here. So the first conclusion has to do with the Google search that was performed which has a timestamp of 227. So this was the famous Google search from Jennifer McCabe. We already heard from Ian Whiffen what his opinion about it was, that it was not done at 227. It was actually done at 6:23 in the morning. And just because the tab was open, that's why he recorded that way. But let's see what Jessica Hyde has to say about this. So this was after she explained how this all works. And here we go with her testimony. Okay. Let's just get there. Okay.
House long to die in cold.
That's correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "how's long to die in cold" was made at the time of the timestamp 227:40?
It's the last time Mr. Massey on this issue, okay?
Okay, so I'm just going to stop it there because this actually was interesting what happened later. And that was that, as you heard, Robert Alessi was the one who was conducting cross-examination. And this is, again, leading up to the ultimate question in this case. What's your opinion, to a reasonable degree of engineering certainty, whatever you want to call it, did you have an opinion about when that search was done? And Robert Alessi kept objecting. So this was where Judge Cannoni said, this is the last time that I'm going to hear you on this issue. Okay, now this was in front of the jury. And actually what happened is that later on, after the break, Judge Cannoni came back in after I think there was maybe the lunch break. She came back in and she told the jurors that, kind of excusing this, saying, the lawyers are just doing their jobs, and you shouldn't read into anything that I'm saying to the jurors, and trying to fix up that comment that she just made. And again, that's an important part, and I think that was a good move by Robert Alessi, because it could be prejudicial. The jury can be hearing from the judge that she's fed up with one side. The jury can feel that, and then maybe they can have a feeling about how the judge feels about the case, and therefore that can affect their own judgment of the case. So that's not something that you want, which is why in front of the jury, everybody tries to act a very specific way. Even when the jury's not there, you may be fighting like cats and dogs, and the judge may be rolling her eyes and huffing and puffing, but in front of the jury, that has to stop. So that was something where, and again, we had this issue with Alan Jackson. A lot of times he could have also brought up this issue where on some of his cross-examination, when he's making certain comments or he's being sarcastic, which again, there's a range of what you're allowed to do in cross-examination. Different judges have more of leeway than others, and we know that Judge Cannoni is very strict on cross-examination, but she would tell the jury a number of times to disregard something that Alan Jackson made and to remind them of the instruction that the lawyer's questions and comments are not evidence. That could also be an area where Alan Jackson could be asking the judge, I think you're prejudicing the jury at this point. You keep cutting me off. You keep instructing them not to listen or to disregard certain questions. You can overrule an objection, and they have an instruction at the beginning of the case, they have an instruction at the end of the case, but to constantly be telling the jury to disregard what I'm saying, or that they should remember, be mindful of the original jury instruction, you can be definitely making the argument that may be too prejudicial. So that's what seemed to have happened here. And then that's why later on, Judge Cannoni kind of took care of this. She wanted to correct this and let the jury know the lawyers are doing their job and everything's fine, and you shouldn't read into anything that's going on over here at sidebar. So, which is good. This is exactly what you should do. But anyway, we're trying to get to this ultimate opinion. There's an objection, and they approach sidebar, and then eventually we get to where she's actually going to give the opinion. So let's just forward through the sidebar here, and we'll get to the ultimate opinion that she's going to give right here. Here we go. As soon as it wants.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 22740 was, whether or not that was the time the search "How's long to die in the cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search "How's long to die in the cold" occurred at 2:27:40 a.m. on January 29th, 2022?
Okay, the objection is overruled.
What I can state to a scientific degree of certainty is that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Okay, so there you have your second expert from the Commonwealth saying that search never happened at 2:27. She can say with certainty, scientific certainty, that it happened at 6:23. But it was the last search that was done in that tab, which was opened at 2:27. So that was Jessica Hyde's first opinion. Now, she also had another opinion. The next opinion is, what about, was that search ever deleted? Was that tab deleted by Jennifer McCabe? This is another issue of the case. So let's see what her opinion is about that.
You've used multiple tools to look at reports regarding this phrase "how long to die in cold" and have seen indications of characterizations of recovered and carved. And in addition to the fact that you actually analyzed the data, did you arrive at an opinion, to a reasonable degree of scientific certainty, whether or not the user deleted the phrase "how's long to die in cold"?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion, to a reasonable degree of scientific certainty, whether any user deleted the phrase "how's long to die in cold"?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
So there's her second opinion. It's not something the user can delete. They can't delete the tabs. And therefore, she said you can clear the cache. She explained the difference between clearing a cache, what we all know about, and deleting tabs. And she said that no, what you're seeing in this report is not actually a deletion of a tab. It's not even possible for a person to delete a tab. It's different than clearing a cache. Okay, we're not going to get into all of the details here, but very clearly her opinion was that Jennifer McCabe did not delete that tab. So now moving on to the final opinion here, the final question, and that was whether there was a deleted call log. I remember the call logs that she made, all those missed calls that she made to John O'Keefe, where those could have been found in a deleted state. What does that mean? So she tried to explain what exactly that means. It could only hold 200 phone calls, and then once you make another phone call, it'll push another phone call out within a certain amount of time. Whatever. And the point is that no, this was not Jennifer McCabe actually deleting the call log. So let's see what she says
when
here.
the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you.
So there you go. So now that was her third opinion, that no, Jennifer McCabe did nothing wrong. That was her opinion here. She didn't do any searches at 227. She didn't delete the searches, and she did not delete the call logs of any phone calls that she made to John O'Keefe that morning, or that early morning after 12 o'clock in the morning. So that was the extent of her direct examination. If you are a computer guy or a computer girl and you understand all this stuff, so then you may enjoy actually her entire testimony, because she's talking about all these wall files and things like that. And okay, so if that tickles your fancy, you can definitely go watch her entire direct examination. So Robert Alessi got up and he conducted the cross-examination. And the first thing that he established was that she was hired by the prosecution, which is, of course, something that you have to do to show who's hiring you and why that may affect your bias and prejudice in this case. So that was the first thing that he pointed out, that she was hired by the prosecution. He didn't get into exactly how much she is paid, which also can be fair game. Again, I don't know in Judge Cannoni's courtroom, but it should be fair game to see how much they're getting paid, the same way that we're going to hear most likely about how the ARCA experts were paid. So that he could have gone into that as well, but he didn't. And then he also wanted to point out some of the inconsistencies in her report. Now, he was able to show that there were some inconsistencies with the phone. For example, in her report, she said that the last interaction with the phone was at 12:20 and 50 seconds a.m. That was the last interaction with the phone that she recorded. And from that point on, there was no interaction with the phone until 6 a.m. However, on Ian Whiffin's report, it shows that the phone was locked by the user at 12:32 and 9 seconds. So according to her report, that's not possible, because the last interaction was done at 12:20 a.m., not at 12:32 a.m. So that was the first point that he made. And she said she didn't look at that specific artifact or whatever it was. Okay, but that was just one good point that he made on his cross-examination. Also, he pointed out another discrepancy where he says that the steps ended until 12:31 a.m. and really the steps that John O'Keefe's phone took was through 12:32. So really she was a minute off there. So he pointed that out. And he also brought up the fact about the steps that John O'Keefe was recorded as making at 12:21 when he was in the car. And then he also pointed out that there was a 5:07 a.m. phone call that Jennifer McCabe made to Coco, who we know is Nicole Albert, and there was no duration for that phone call. And also, there's no duration reported from 12:14 a.m. through 5:07 a.m. All the phone calls there was no duration until 8:59 a.m. So he pointed that out. Then he spoke a lot about there was also another mix-up with she recorded something in UTC instead of EST. So that was another mistake that he found in her report. And he also then spoke about Celebrite, that the Celebrite report did at one point show this 227 timestamp, and then they removed that 227 timestamp from Celebrite's tool. And then he got into whether it's more accurate to use Apple source codes, and she maintained that no, it's not any more reliable to use Apple source codes, which really gets back to some of the opinion, I think, in in that original opinion that they were arguing about, where this judge found that maybe some of her opinions were not reliable because she didn't have the Apple source code. So this could be a misunderstanding. It could be just people are not as educated about this, how all this works. I think a lot of this, again, like I said, went over to a lot of people's heads. But she was maintaining that even though we don't know the Apple source code, but it's no more reliable than the tools that she was using. Okay, so that was really, I mean, he also pointed out one final fact, which became an issue, was the fact that the best practice was for the phone to be isolated from the device, from the network. You got to isolate the device from the network when you are taking a phone to extract. You got to put it in airplane mode or put it in a Faraday. And I'm maybe saying that word wrong. Faraday. I think it's Faraday. So there's a Faraday bag or box that you're supposed to put the phone in, which would make it that it cannot have any sort of signals to it. So that wasn't done in this case. But on redirect, Hank Brennan pointed out that would have changed her opinion at all, whether it was put in this Faraday or not, whether it was put in airplane mode or not. And she said, no, that wouldn't have changed any of her opinions anyway. So also another interesting point that she made was the fact that these steps that the Apple health data shows, this Apple health data shows, could be manipulated. Doesn't necessarily mean that you're actually walking with the phone. It could be manipulated if you're on your bike, if you're in a car. Based on the motion of the device, it can start recording steps, even though you're not actually taking steps, which is obviously a very important part in this case, because John O'Keefe's phone was recording steps while he was in the car. And also, I mean, according to the Commonwealth's theory, and that he was going up and down stairs at a certain point. So 3 flights of stairs climbed. So that is what their case is going to be, the Commonwealth's argument. And we heard from Jessica Hyde and Ian Whiffen that it's possible for the phone to record these steps, even though he is in the car. Now, again, I'm just going to point out the fact that I think it really goes against your common sense. Because you would think, and I think this could have been brought up in cross-examination. I'm not sure why it wasn't done, but you would think that if Apple is spending who knows how many millions of dollars into this technology, that you can't just very easily manipulate it. Otherwise, there's no point of the technology. What's the point of having a phone record your steps if it's so easily manipulated? If you're in the car every time, who's not in the car? When you're in the car, it's recording steps. What's the point of having this steps feature as part of your phone? There's really no point of it. So again, I think it just goes against common sense in this case that you can manipulate the phone so easily to start recording steps and flights climbed when you would imagine that Apple's spending millions of dollars on this technology. So again, even though we heard from 2 witnesses, I think you can still use the argument of common sense to the jury to make that type of argument. Now, the last thing that happened today was the final clip of one of Karen Reed's Docuseries, and this was in April 30th, 2024, I think it was. And let's see this last clip, okay? Because again, it doesn't look the greatest for for Karen Reed. Let's hear what she has to say. I'm going to again just slow it down a drop so you can hear the full extent of this clip. Yeah, there it is, April 30th, 2024.
Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
So that was the extent of the clip there. Either I'm going down, Jen, or you are. It's like me or her. And that's really not the way you want the jury thinking about this case. You do not want this to be a case of Jennifer McCabe versus Karen Reed and whether she did the Google search. That's really not what you want the jury thinking about. What you want the jury thinking about more is whether her car actually hit John O'Keefe. That's what you want the jury thinking about. And you want the jury thinking about, if you're the defense or if you're Karen Reed, you want the jury thinking about the investigation. You want them thinking about Michael Proctor. You want them thinking about the misconduct in this case, the inappropriate statements, the inappropriate text messages that we're going to be hearing about. That's what you want them concentrating about. You don't want the jury thinking, am I going to pick Jennifer McCabe or am I going to pick Karen Reed? That's not what you want the jury thinking. So again, these clips are not helpful for Karen Reed. They're not. And Hank Brennan is using them definitely to his advantage to try to convince the jury or try to make the jury make certain judgment calls about who Karen Reed is. So again, this is like her testifying without her taking the stand. They're hearing statements from her. They're hearing certain personality traits from her. They're hearing, and they can very simply easily make judgment calls about who this person is, Karen Reed. And that's not what you want. That's not what you want as the defense. So, I mean, but this is what the defense has to deal with. That's what it is. So you want the jury, and this is what you have to do if you're the defense. You want the jury thinking about the accident, whether this accident is possible to happen, how botched this investigation was, and Michael Proctor. That's really what you want them concentrating on. And again, Hank Brennan just using these clips to his advantage. So that was the extent of day 11. We're looking forward to day 12. You can definitely join us tomorrow right here, Brother Counsel Studios. We'll be live streaming it starting at 9 a.m. We always have a good time. The chat is always good. And so we'll see you back here tomorrow on Thursday, May 8th, 9 a.m. for the continuation, day 12 of Karen Retrial. That's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.